Dear students, I welcome you to today's introductory lecture on company law. In today's lecture, we shall understand the meaning of a company. We shall also understand the advantages that flow from the incorporation of a company. We begin by understanding the term company. The word company is an amalgamation of the Latin word cum, meaning with or together, and panis, meaning bread. Originally, it referred to a group of persons who took their meals together. A company is nothing but a group of persons who have come together or who have contributed money for some common purpose and who have incorporated themselves into a distinct legal entity in the form of a company for that purpose. In India, companies are governed by the Companies Act 2013. If we look at the definition provided by the Companies Act, it says, company means a company incorporated under this Act or any previous company law. Clearly, an association or organization registered under the Companies Act 2013 or the Companies Act 1956 or any previous company law can qualify to be called a company. Such a definition does not throw much light on the nature or characteristics of a company. The nature and characteristics of a company can be understood in the light of common law. The greatest distinguishing feature of a company is that it is independent and separate from its members. The members are not liable for the acts of the company. This was held in the case of Solomon versus Solomon and Company Limited. Solomon successfully ran the business of bootmaking in the form of a sole proprietorship. He transferred his business of bootmaking to a company, that is Solomon and Company Limited. The members of the company comprised of Solomon and his family. The price for such a transfer was paid to Solomon by way of shares and debentures having a floating charge, that is security against a debt, on the assets of the company. Later, the company's business failed and it went into liquidation. On winding up, the company's balance sheet stood as the assets £6,000, liabilities Solomon as a debenture holder £10,000, unsecured creditors £7,000. Solomon's right of recovery, which was secured through a floating charge against debenture, stood higher in priority to the claims of the unsecured creditors, who would thus have recovered nothing from the liquidation proceeds. The unsecured creditors contended that the company did not have any independent existence. The entire command and control of the company was vested in Solomon. Even though the company was incorporated under the Act, nonetheless, it did not have any independent existence. The business was solely his, carried on solely for him and by him. However, it was held that Solomon and Company was a distinct legal entity. The House of Lords held that when a memorandum is duly signed and registered, though there may be only 7 shares taken, the subscribers are a body corporate capable forthwith of exercising all the functions of an incorporated company. It is difficult to understand how a body corporate, thus made capable by the statute, can lose its individuality by issuing the bulk of its capital to one person, whether he be a subscriber to the memorandum or not. The company is, at law, a different person altogether from the subscribers to the memorandum. And though it may be that after incorporation, the business is precisely the same as it was before, and the same persons are the managers, and the same hands receive the profits, the company is not in law the agent of the subscribers or trustees for them, nor are the subscribers liable as members in any shape or form except to the extent and in the manner provided by the Companies Act. The decision of the Calcutta High Court in Re Condolly Tea Company recognized the principle of separate legal entity even much before than the decision in Solomon versus Solomon and Company Limited. In this case, certain persons transferred a tea estate to a company and claimed exemptions from ad velorum duty on the ground that since they themselves were also the shareholders in the company, it was nothing but a transfer from them in one name to themselves under another name. While rejecting this, the Calcutta High Court observed the company was a separate person, a separate body altogether from the shareholders, and the transfer was as much a conveyance, a transfer of the property, as if the shareholders had been totally different persons. In Dhulia Amalner Motor Transport Limited versus Raichand Rupsi Dharmasi, a partnership firm, Dhulia Amalner Motor Owners Union carried on the business of plying buses. After having worked for some time, some of the partners of the firm formed a private limited company, that is Dhulia Amalner Motor Transport Limited. The partners of the firm who formed the company sold to the company their own buses, which were heretofore being used by the firm. Under the terms of the partnership deed, a partner could sell to a third person his bus or buses which he had given to the firm for the use for the business of the firm. In this case, the company was the said third person to whom the partners of the partnership firm sold their buses after withdrawing them from the firm. The other set of partners who constituted the minority sued the section forming the company for accounts and their share of profits on the ground that in reality the company was not a different entity from the firm and that the business carried on by it was the same as that of the firm. The issue involved in this case was whether Dhulia Amalner Motor Transport Limited, a company registered under the Companies Act 1913, was a separate entity from its members, and the partnership firm Dhulia Amalner Motor Owners Union, of which its shareholders were members. The respondents contended that the private limited company's name, Dhulia Amalner Motor Transport Limited, was merely an alias for Dhulia Amalner Motor Owners Union, and in reality the company was not a different concern and was not a different entity from the union itself. They also contended that the majority section of the partnership firm was using the artificial creation of the company as their agent for doing the business with the property of the partnership firm. The court rejected the contentions of the respondents and held that the plaintiffs had no legal right to sue for the accounts of the business done by the company, which was altogether a third person. Buses which the company was plying were not the property of the partnership firm, nor the property of any of the partners of the firm, nor the property of the shareholders, but the property of the company itself. It was also held that the limited company in substance and in form was not the same entity as the union, with merely a changed name. The company has a distinct entity of its own, quite different from the entity of the union and the entities of the shareholders, and the business which was done by it was not the same as was done by the union, nor was it a continuation of the same business. The business which was done by the company was distinctly its own business. It was not the business of its shareholders either. The motives for becoming shareholders is not a field of inquiry. The law recognizes the existence of the company quite irrespective of the motives, the intentions, the schemes, or the conduct of the individual shareholders. Another case on the point would be the case of Lee versus Lee's Air Farming Limited. This case illustrates the application of the principles established in Solomon's case. In this case, a company was formed for the purpose of aerial top dressing. Lee, a qualified pilot, had all but one of the shares in the company. He voted himself the managing director and got himself appointed by the articles as chief pilot at a salary. He was killed in an air crash while working for the company. His widow claimed compensation for the death of her husband in the course of his employment. The company opposed the claim on the ground that Lee was not a worker, as the same person could not be the employer and the employee at the same time. The Privy Council held that Lee and his company were distinct legal persons who had entered into contractual relationships under which he became the chief pilot, a servant of the company. In his capacity as managing director, he could, on behalf of the company, give himself orders in his other capacity of a pilot, and the relationship between himself as the pilot and the company was that of a master and a servant. Lee was a separate person from the company he had formed, and his widow was held entitled to get the compensation. In effect, the magic of corporate personality enabled Lee to be the master and the servant at the same time and enjoy the advantages of both. In Union Bank of India versus Khadar International Constructions and others, the question which arose before the court was whether a company is entitled to sue as an indigent person under Order 33, Rule 1 of the Civil Procedure Code 1908. The aforesaid order permits persons to file suits under the code as paupers or indigent persons if they are unable to bear the cost of litigation. The appellant in this case had objected to the contention of the company, which had sought permission to sue as an indigent person. The point of contention was that the appellant, being a public limited company, was not a person within the purview of Order 33, Rule 1 of the Code of Civil Procedure, and the person referred to only a natural person and not to other juristic persons. The Supreme Court held that the word person mentioned in Order 33, Rule 1 of the Civil Procedure Code included any company as association or body of individuals, whether incorporated or not. The court observed that the word person had to be given its meaning in the context in which it was used, and being a benevolent provision, it had to be given an extended meaning. Thus, a company may also file a suit as an indigent person. The other advantages that flow from incorporation are that a company has perpetual existence. A company, being a separate legal person, is unaffected by the death or other departure of any other member, but continues in existence no matter how many changes in the membership occur. Its life does not depend upon the death or insolvency or retirement of any or all its shareholders or directors. Law creates it, and it is law alone which can dissolve it. Members may come and go, but the company can go on forever. During the war, all the members of one private company, while in a general meeting, were killed by a bomb. But the company survived. Not even a hydrogen bomb could have destroyed it. The company may be compared with a flowing river where the water keeps on changing continuously, still the identity of the river remains the same. Thus, a company has perpetual existence irrespective of the changes in its membership. In Punjab National Bank versus Lakshmi Industrial and Trading Company Limited, the court held that the guarantors of a company's loan could not escape liability by relying on the fact that the management of the company had changed, including its managing director. Such changes do not affect the continuity of the company, including its contractual or commercial relations. The next advantage of a company is that it has limited liability. The basis of limited liability is that all debts incurred by a company are the company's liabilities and are not directly the legal liabilities of the shareholders or of the directors of the company. The company is a separate legal person from its shareholders and directors. The company incurs debts in the course of its business, and only the company is liable for those debts. A company may be a company limited by shares or a company limited by guarantee. In a company limited by shares, the liability of the members is limited to the unpaid value of the shares. For example, if the face value of a share in a company is Rs 100 and the member has already paid Rs 80, per share, he can be called upon to pay not more than rupees 20 per share during the lifetime of the company. In a company limited by guarantee, the liability of the members is limited to such amount as the member may undertake to contribute to the assets of the company in the event of its being wound up. Justice Buckley in Re London and Globe Finance Corporation has observed, I quote, "The statutes relating to limited liability have probably done more than any legislation of the last 50 years to further the commercial prosperity of the country. They have, to the advantage of the investor as well as to the advantage of the public, allowed and encouraged aggregation of small sums into large capitals which have been employed in undertakings of great public utility, largely increasing the wealth of the country." Unquote. In J.H. Reiner Limited versus the Department of Trade and Industry and others, it was held that no member is bound to contribute anything more than the nominal value of the shares held by him. The next advantage of forming a company is the transferability of shares. Transferability is an important feature of a company registered under the Companies Act. Section 44 of the Companies Act states that the share shall be a movable property and transferable in a manner provided by the articles of the company. In a public company, the shares are freely transferable. The right to transfer shares is a statutory right and it cannot be taken away by a provision in the articles. However, the articles shall prescribe the manner in which such transfer of shares will be made, and it may also contain bona fide and reasonable restrictions on the rights of the members to transfer their shares, but absolute restrictions on the rights of the members to transfer their shares shall be ultra vires. However, in the case of a private company, the articles shall restrict the right of the member to transfer their shares in the companies with its statutory definition. In order to make the right to transfer shares more effective, the shareholder can apply to the central government in case of refusal by the company to register a transfer of shares. The next advantage of forming a company is that a company has its own separate property. As a company is a legal person distinct from its members, it is capable of owning, enjoying and disposing of the property in its own name. Although its capital and assets are contributed by its shareholders, they are not the private and joint owners of its property. The company is the real person in which all its property is vested and by which it is controlled, managed and disposed of. The creditors of the company can recover their money only from the company and the property of the company. They cannot sue the individual members. Similarly, the company is not in any way liable for the individual debts of its members. The property of the company is to be used for the benefit of the company and not for the personal benefit of the shareholders. On the same grounds, a member cannot claim any ownership rights in the assets of the company either individually or jointly during the existence of the company or in its winding up. In Bacha F. Gazdar versus the Commissioner of Income Tax, the Supreme Court held that the company is a juristic person and is distinct from its shareholders. It is the company which owns the property and not the shareholders. The owner of a timber estate sold all the timber to a company which was owned almost solely by him. He was the company's largest creditor. He insured the timber against fire but in his own name. After the timber was destroyed by fire, the insurance company refused the claim. The House of Lords held that in order to have an insurable interest in the property, a person must have a legal or equitable interest in that property. The claim failed as the corporator, even if he holds all the shares, is not the corporation. Neither he nor any creditor of the company has any proprietary, legal or equitable rights in the assets of the corporation. In Subra Mukherjee versus Bharat Coking Coal Limited, which was a case pertaining to the nationalization of coal mines, a transaction of the sale of its immovable property by a company in favor of the wives of the directors, was alleged to be a sham and collusive. The court pierced the veil of incorporation to ascertain the true nature of the transaction as to who were the real parties to the sale and whether it was a genuine and a bona fide transaction or whether it was a sham. The court held that it was a sham and that the property continued to vest in the company and therefore belonged to the government. In H.C. Shastri versus Dolphin Can Pack Private Limited, it was observed that neither a shareholder nor a director has any right in the property and assets of the company, which is a separate juristic entity distinct from the shareholders. The shareholder who buys shares does not buy any interest in the property of the company, which is a juristic person entirely distinct from the shareholder. The shareholder, as an investor, becomes entitled to participate in the profits of the company and have a say in the management as per law. The court held that the assets of the company cannot be used for the payment of the shareholders' debts. The company, being a body incorporated by law, holds the characteristics of separate legal entity. The company has its own name and can sue and be sued under its own name. The members of the company can enter into contract with the company in the same manner as any other individual can. Companies can claim for the damage caused to it or to its name by suing them. In one of the cases, the court held that the exhibition of the struggle of workmen against the management of the company is the infringement of privacy of the company and should be restrained. The court in this case held that the company can complain under the Broadcasting Act 1996 for anything which is an infringement of the privacy of the company. In Aspro Travel Limited versus Owners Abroad PLC, it was held that just as a person has a right to his reputation, a company also has a right to protect its name from being tarnished and can sue the third party for a defamatory statement made by him or her against the company as are likely to damage the business or property of the company. The next advantage for forming a company is delegated management. A joint stock company is an autonomous, self-governing and self-controlling organization. Since it has a large number of members, all of them cannot take part in the management of the affairs of the company. The actual control and management is therefore delegated by the shareholders to their elected representatives known as directors. They look after the day-to-day working of the company. Moreover, since shareholders by majority of the votes decide the general policy of the company, the management of the company is carried on democratic lines. Majority decision and centralized management compulsorily bring about unity of action. Dear students, this was all with regard to the advantages of incorporation. Hope you understood it and enjoyed the lecture. Thank you.